So welcome to today's webinar, Prepare Your Business for Legalization. My name is Sylvie Lipsard and I'm with CFIB. Before we start, I have a few housekeeping items. First of all, on your control panel, you will see a questions box where you can type in your questions at any time during the webinar. We will do our best to answer all your questions during the Q&A at the end. If you need more information after the webinar, please contact CFIB for further help. Also, in the control panel, I highly recommend that you go to the section handouts now, where if you click on the down arrow, you will see a copy of the PowerPoint slide that will be presented today, along with a drug and alcohol template that was created by Fasken. Please know that we will send you a recorded version of this webinar tomorrow in an email with a link to further information. CFIB is very pleased to present this webinar hosted by Fasken, a leading law firm with offices around the world. Rhonda Grintuck, our host today, is a lawyer with the firm's Labor, Employment, and Human Rights Group. With the practice covering all aspects of employment law, she provides employers strategic advice on hiring, layoffs and dismissals, human rights, and federal and provincial employment standards. A big thank you to Rhonda for being here today. I will now pass the floor over to you. Over to you, Rhonda.
Thank you. Thanks, Sylvie. Thank you, everyone, for being here with us today. It's a pleasure to be speaking with you and be hosting this webinar. Let's get right to it. So there's going to be a few topics that I'm going to address with you this afternoon. The first one is the legalization of recreational marijuana, something that I'm sure each and every one of you has been hearing a lot about as we anticipate the October 17th impending date of the coming into force of this new legislation. The second topic is going to be marijuana use in the workplace and what are impacts that employers should be aware of and can start to prepare for. And the third topic will be workplace drug and alcohol policy and other considerations. So we've prepared a sample policy for your consideration, and I'll be going into detail on a few considerations with regard to that policy. The legalization of recreational marijuana is going to happen, as I mentioned, on October 17th, just in a couple of weeks. And it's going to come into force under Bills C-45 and C-46, one of which is called the Cannabis Act. These are federal legislations that are going to provide for strict regulation of access to cannabis, particularly where youth are concerned. For those who are the age of majority, being over the age of 18, they will, as of October 17th, under this federal legislation, be able to buy, possess, grow, and use cannabis recreationally. Now, something you should know is that provincial regulations and restrictions are going to come into force on the same date as the federal legislation, and they'll provide for additional restrictions that apply to the distribution of cannabis and workplace health and safety. Now, another point to mention here is that the medicinal use of marijuana is already legal, as you might know, under the Federal Access to Cannabis for Medical Purposes regulations, and those regulations will remain unchanged with the coming into force of Bill C-45. So you shouldn't expect to see any changes or any amendments to the law as it already exists with respect to medicinal use of marijuana. So under Bill C-45, what is going to be allowed? As I mentioned, the permissive use of cannabis is going to apply to individuals over the age of 18, and they will be able to possess up to 30 grams of dried cannabis. They'll be able to share less than 30 grams of dried cannabis, and they'll be able to possess up to 4 cannabis plants per residence. A little aside here, each province has their own take on the possession of cannabis plants. Some of the provinces have actually outlawed the possession of cannabis plants. So depending on the province you're in, you'll want to check what the regulations are in that regard. For example, in Quebec, the Quebec regulation that will be coming into force does not allow possession of cannabis plants. There's certainly a conflict of laws here that this brings up, and this is something that we expect to see come before the courts in the upcoming months. So hopefully we'll eventually get a clear answer on whether possession of cannabis plants is permitted or not in each province. As another aside, you'll see that edibles are not mentioned on this PowerPoint slide. Edibles are not going to be permitted under the federal legislation that's coming into force. It will, however, continue to be available to people with a prescription. So only those having a prescription will be allowed to legally use or consume edibles. So what is going to be permitted under Bill 45 with respect to driving? Oops. Driving under the influence is going to be permitted only for those who have consumed less than 2 nanograms of cannabis. That will be considered legal under the legislation that's coming into force. However, anywhere between 2 nanograms and 5 will be considered illegal and will be subject to a fine. More than 5 nanograms is considered illegal and will come with the possibility of incarceration. And mixing drugs and alcohol is going to be considered a no-no, depending on the quantities of each substance. That will be considered illegal as well, depending on the quantity of each that has been consumed. And what I've provided for on the slide in front of you is a snapshot of the regulations for some of the provinces. So here you have the title of each of the bills in each of the provinces. They've all received royal assent and will be coming into force on October 17th, along with the federal legislation. Each of the provinces and territories have provided for their own regulations. I don't have them all here on the screen, but they're largely similar from one province to the next. There are some distinctions. To give you a brief overview of what these bills provide. So they each regulate where cannabis might be consumed. In Quebec, for example, it's going to be permitted to be smoked where tobacco is already permitted, with the exception of university campuses. In Ontario, for example, cannabis can be smoked in private dwellings only. In British Columbia, it's going to be a little bit more heavily restricted. So they've carved out areas where you are not permitted to consume cannabis, including vehicles, areas frequently used by children, health facilities, and parks. There's some others. In Alberta, cannabis can be consumed where tobacco is permitted, with some exceptions. For example, in vehicles and in areas frequently used by children. And like I said, each province and territory has enacted their own particular regulation, which restricts the areas in which cannabis can or cannot be consumed. And they all vary from one province to another a little bit, but in general, they all tend to look quite similar. And just a brief mention here, the regulations are also going to provide for certain obligations with regard to employers and employees in the workplace. And For example, in Quebec, the Quebec Bill 157 is going to provide that workers must not perform their work if their condition represents a risk to health, safety, or well-being of themselves or others in or around the workplace due to impairment by alcohol, drugs, including cannabis, or other similar substances. And another article that's going to be included in Bill 157, which amends the Occupational Health and Safety Act, is an obligation on employers to ensure that their workers do not perform when they're under the influence and their condition might pose a danger or a risk to the health, safety, or physical integrity of employees or others in and around the workplace, again, due to alcohol or drugs, including cannabis or other similar substances. So each of the provinces have enacted similar restrictions as to conduct in the workplace, and particular in order to address safety concerns. Marijuana in the workplace. What should employers be aware of? What issues can you expect to face? An increase in marijuana use among Canadian workers will certainly present challenges for employers with respect to safety, absenteeism, and productivity, to name a few. Even before the legalization of marijuana was being discussed, reports at the time estimated that consumption of psychotropic substances and alcohol was already leading to a productivity loss that was quantified as being more than 1 billion annually, and as well as absenteeism rates that were 3 times higher than the average and a 30% lower than average performance rate. Other studies, this one refers to a study completed in 2007. At that point, 8.4% of workers had used illicit drugs in the last month. So it is somewhat disturbing to think that these statistics are likely, if anything, to increase once marijuana is legalized and becomes perhaps more widespread. Now, why implement a workplace policy? There's several reasons. In the first place, it's well recognized that it's a legitimate goal for employers to establish a policy to this effect in order to ensure a safe workplace. And employers do have recognized legal duties to provide for a safe workplace. So potential consequences of not addressing the legalization of marijuana could, for example, lead to an increase in accidents in the workplace and could even invoke the employer's legal liability. So we highly suggest that this topic be discussed in the workplace and that it certainly be addressed under a policy that would come into force very soon if it hasn't already been addressed, but it's certainly something that every employer should be turning their minds to in advance of the October 17th date. Employers should know that impairment, whether from drugs, including drugs that are or will be legalized, alcohol and prescription medication, can have a serious adverse impact on the workplace. So a policy like the one that we're proposing to you is going to be really an essential tool to ensure that employees are able to perform their work in a safe and suitable manner. And this is all in accordance with an employer's recognized management rights. So an employer certainly has the right to be establishing policies and be regulating behavior in and around the workplace. Now, another goal that establishing a workplace policy will help to achieve is to strike a balance between having respect for employees once they're in their private sphere versus the need to maintain an impairment-free work environment and ensure that any behaviors that an employee might have when they're in their private sphere won't carry over and have an impact on the workplace. Now, in conjunction with establishing a workplace policy regulating drugs and alcohol, what other steps should an employer be taking at the same time? We suggest that employers evaluate all of the company policies that are currently in effect, particularly any policies that might have an impact or might be impacted by the legalization of marijuana. For example, safety standards and prohibitions against various forms of conduct. For example, safety sensitive positions, what requirements apply to those positions and what policies might already be in effect with regard to those specific positions. Any policies that might already be in effect with regard to drug testing, zero tolerance, fitness for duty, and as well as any policies with regard to medical accommodation. So these should all be evaluated in conjunction with the employer turning their mind to establishing a workplace drug and alcohol policy if one is not already in effect. We recommend that these company policies undergo an annual review. And another step that we recommend is that employers take the time to have a meeting with employees, whether it be a sit-down meeting or through some other form of communication, in order to ensure that employees understand what the legalization of marijuana means for the workplace, what their obligations are, what their rights are, what obligations the employer is going to have. Any specific training could be provided at that time as well, specifically for safety sensitive positions. The employer could also take the opportunity to explain what their policy on drug and alcohol is, and any nuances or responsibilities that the employee should be aware of. The employer can also explain the difference between medicinal and non-medicinal use of marijuana and explain how those will be treated differently in the workplace, as well as the various forms of disciplinary action that could be taken if ever the employer is confronted with a violation of the policy that has occurred. And another point that could be addressed during this meeting with employees is the accommodation process. So for those employees that have a recognized disability or handicap due to dependence on drug or alcohol, what specific steps will the employer take in their particular case? Now, turning to the sample policy, which we've prepared for you, the who, the what, and the where. First of all, who should be covered by this policy that we suggest you put into place in the workplace? We suggest that all employees while on duty be covered by the policy and be bound by it. What we mean by on duty is anytime an employee is in the workplace or even outside of the workplace when they are acting for work-related purposes. So this would include anytime the employee is on a paid or unpaid break, as well as anytime an employee is on an on-call period. And again, the policy would cover employees whether or not they find themselves in the workplace at a particular time. So if they are currently outside of the workplace, they would still be bound by the workplace policy if, for example, they're representing the employer outside of the company's property and premises. That could include any time the employee is on a job site or on customer property. And I'll give you a few other examples in the next slide. But it's not only employees who should be covered by the policy. We suggest that all consultants, independent contractors, and other service providers be covered by the policy as well, either while they're on company premises, but also while they're performing work for the company, even outside of the premises. So a few examples of instances that should be covered by the policy. Various company events that could include an annual holiday party, lunches with clients, social events or other activities or events sponsored by the company, any event or activity where the company name is advertised or where the employee is going to be seen as representing the company. What substances should be covered by the policy? Certainly alcohol, illegal drugs, and now the recreational use of marijuana should all be covered. And a final point that we don't always turn our minds to, but prescription medication should also be covered by the policy. And you'll see a little bit later in the presentation that we have a few specific pointers with regard to prescription medication and what that could entail for the workplace. So an important aspect of the sample policy, as you'll see, is having a clear statement on fitness for duty. What is fitness for duty? It means when a worker is able to safely perform assigned duties without any limitations resulting, but not being limited to the use or after effects of drugs, alcohol, and/or prescription medication. So conduct that is in violation of the fitness for duty policy should be clearly prohibited under the employer's policy. Essentially, what this means is that the policy should prohibit reporting for duty or remaining for duty anytime the employee is considered to be under the influence of drugs or alcohol, or even the improper use of prescription medication, meaning that their faculties are impaired or are likely to be impaired due to consumption of various substances. The policy should also clearly enumerate what types of conduct are going to be prohibited. And what we suggest is that the possession, the use, the sale, the transfer, the dispensation of any illegal drugs or paraphernalia, as well as cannabis for recreational purposes, be strictly prohibited. We also recommend prohibiting the possession of open containers of recreational marijuana on company premises. And we also suggest that the policy provide for a prohibition against the improper use of prescription medication during working hours or on company premises or customer property and job sites. Another form of conduct that should be specifically prohibited under the workplace policy should be operating company vehicles or any form of machinery or equipment while under the influence. And again, when I refer to under the influence, what I mean is any instance in which an employee's consumption of alcohol or illegal drugs or recreational marijuana, as well as improper use of prescription medication, could impair the employee's job for performance at a time while the employee is considered to be on duty. Determining impairment in the workplace, this is an issue that an employer should certainly be alive to and hopefully won't be confronted with. But due to testing technology limitations, which I'll get into in a couple of slides to come, An employer, what's going to become extremely important is an employer's direct observation in the workplace. This is going to be key in determining scenarios in which an employer suspects that an employee is impaired because he or she has been consuming cannabis or other substances. Now, an employer should keep in mind that effects of consuming marijuana depend on a variety of factors, including the specific individual, the setting in which the substance was consumed, the amount that was consumed, and the concentration of THC in the substance. And certainly this is going to present challenges for detecting consumption within the workplace. And this is why we say that direct observation is going to be key. Now, certain tests or instances of interaction that an employer could look to are discussions with an employee. Are they having words, or is their language different markedly from how the employee normally speaks or normally behaves? And the employer should also observe employees' completion of simple job-specific tasks. Is the employee doing anything that is markedly different from how they normally perform their tasks, for example? Now, keep in mind that direct observation and perhaps noting any differences in behavior or in workplace performance is not going to be conclusive of drug consumption or alcohol consumption, but it is certainly going to be an important indicator, particularly in light of limitations that we see with the testing technology as it currently exists. Now, just to go a little bit more in depth in particular symptoms that an employer could be alive to in the workplace in order to detect possible consumption of drugs or alcohol. As far as physical symptoms are concerned, you might see profuse sweating, an increase in headaches or tremors, restlessness. Certainly an odor is going to be an important indicator, an odor either of alcohol or cannabis. Slurred speech or unsteady gait or glassy eyes. You might also see some psychosocial symptoms, including confusion or memory lapses, inappropriate responses or behaviors of an employee, and lack of focus or concentration where that didn't occur before. An employer might also see an impact on an employee's workplace performance if they've been consuming drugs or alcohol, such as increased forgetfulness or deterioration in performance. Now, these symptoms aren't specific just to cannabis consumption, but could relate to consumption of other substances as well, and even improper use of prescription medication. And again, these are just examples of signs and symptoms that an employer could look out for in the workplace in order to perhaps give a hint of problematic substance use, but it's not going to be conclusive 100% of improper substance use. With respect to marijuana use, some specific short-term effects that we know about are forgetfulness, decreased concentration, slowed reaction times, increased appetite, dilated pupils, and red eyes. And any of these symptoms could create difficulties for an employee in performing their workplace duties safely and effectively, particularly if the employee is going to need to drive or operate machinery in the context of their functions. And just a further note, again, these symptoms are going to certainly vary from person to person, and that's why determining impairment should be done on a case-by-case and individualized basis. And the symptoms here on the PowerPoint are not indications or are not signals that someone necessarily has a substance abuse problem, but they could also signal that an employee might be having some trouble struggling with some form of dependency. And that might be a call for help and lead to intervention by the employer. Now, if the employer thinks or knows concretely that a policy violation has occurred, what steps should be taken? The first one is going to be certainly to immediately undertake an investigation of the facts of the situation. So this should be done whenever the employer has reasonable grounds to believe that an employee is impaired in the workplace or outside of the workplace at any time, for example, that they're representing the employer or that they find themselves on a job site or interacting with a customer. The investigation would involve meeting with the employee in question in a private setting and ensuring to get their full version of events. The employer would also have an interest in meeting with any other employee or witness to the suspected violation. And the employer will also want to evaluate any material evidence or any documents that could confirm or deny that there's been a possible violation of the policy. And ultimately, the employer should reach a conclusion on whether or not it believes that there's been a policy violation. And the standard on which the conclusion will be drawn tends to be a 50% plus standard, the balance of probabilities. So if the employer is more convinced than not that a policy violation has occurred on a balance of 50% plus 1, then that would enable the employer to conclude that there has been a policy violation. Again, we're not looking for a determination beyond a reasonable doubt, which is the criminal law standard. We're talking about a balance of probabilities, which is 50% plus 1. Now, potential outcomes after a policy violation has been determined, it's going to depend certainly on the facts of the matter and the seriousness of the violation, as well as the particular laws that apply in the province in which you find yourself, or any case law that has been developed in prior years. But generally, consequences will include disciplinary measures, which could go up to and including immediate discharge. An important point to keep in mind is that investigations should be treated confidentially by the employer. Now, the sample policy that we've provided and the one that you will eventually put into effect in the workplace, I wouldn't recommend that the employer promise 100% confidentiality in other situations. The employer is rather going to want to keep a reserve with regard to their confidentiality obligations. So you're going to want to state that the employer will maintain the confidentiality of the investigation and of any information that's gathered with regard to the investigation to the fullest extent possible. And the reason that you might want to keep that reserve is in the case of any litigation, for example, that could ensue, such as perhaps an employee will be terminated after a violation has been determined, and the employer is going to want to be able to prove their case to the fullest extent. And to do so, the employer might need to rely on investigation reports that might have been prepared in the context of the investigation, or any witness statements that were taken. And the employer might also want to call upon certain witnesses that would tend to be employees in the workplace. And so the employer is going to want to guarantee confidentiality for the employees who are involved in the investigation or participating in the investigation, but only to the fullest extent possible. Now, it's a different situation with employees who are participating in the investigation as potential witnesses. The employer is going to want to ensure that they're aware that they have an obligation to maintain the full confidentiality of the investigation. So any information that is given, that the employee gives to the employer, or that the employee receives from the employer in the context of the investigation, should be kept strictly confidential by the employee. And they should know that violations of their confidentiality obligations could lead to disciplinary action up to and including termination of employment. And the interest in having a policy to that effect is to ensure that the situation that the employer has to deal with doesn't take on overblown proportions, isn't discussed, by the water cooler, and that's out of a show of respect for the employee that is going to be involved in the possible policy violation, and to ensure that the employees are able to continue to perform their duties in good order without being distracted by possible rumors or by situations going on in the workplace that should really be treated confidentially. Testing technology and its limits. Now, in conjunction with this topic, we've provided for a separate PowerPoint presentation that you might want to take a look at, particularly if you have employees in your workplace who are in safety-sensitive duties. This separate PowerPoint is going to be of specific interest to you. Now, generally, an employer is able to ask an employee to undergo a drug or alcohol test in very specific circumstances. The first one is reasonable cause testing. And by this we mean any time where an employer has reasonable grounds to suspect that an employee who is considered on duty is under the influence, or to put it another way, is not fit for duty. The second scenario in which drug and alcohol testing sometimes takes place is post-incident. So by that we mean that the employer now has reasonable grounds to believe that an employee who was involved in an accident was impaired during the performance of their duties. And this is going to be for only for employees who were directly involved in an accident or in a serious incident or even a near miss, not for any employee in the workplace. The third topic is post-reinstatement testing. So this refers to an employee returning to work after being treated for drug or alcohol abuse. The fourth one here is randomized testing. So for this particular form of testing, the employer is going to have to demonstrate that there is an alcohol or drug problem, for that matter, in the workplace. And in very specific circumstances, random testing will be permitted, but the burden is going to be very heavy, and it's going to be on the employer to demonstrate that there is a veritable alcohol or drug problem that would justify randomized testing. And the last aspect is pre-employment testing. So this means before an employment offer has been made, or potentially in conjunction with a conditional offer of employment. Now, all of these forms of testing are very strictly regulated. Most employers won't want to rely on testing in the workplace because it is very invasive, and provincial privacy legislation is going to regulate the exact circumstances in which testing could be performed. But this slide will give you just a brief idea of what forms of testing exist and in what types of scenarios within employment an employer might want to perform drug or alcohol testing. And again, I'd refer you to the PowerPoint presentation on testing and testing technology and its limits for a little bit more information on this. There are various forms of testing technology out there currently. Saliva testing tends to be the most popular. and is becoming increasingly common. Now, the benefit is that it gives near instantaneous results, but questions have been raised as to its accuracy to be able to detect cannabis consumption. Urinalysis is another form of testing that tends to be much less common and has a higher accuracy rate, but the results are delivered in a much longer time frame. Blood testing is the last form of test and is the least common, will most likely only be relied on by the authorities or in medical settings, and tends to be highly accurate, but again, the results take a long time to come through. And the various windows of detection for detecting substance, such as cannabis or alcohol in the body, can vary anywhere from 3 to 6 hours up to 30 days. So the form of the test and the manner in which it's performed is going to lead to widely different results. And with all of these forms of tests, it still remains extremely difficult to determine based on testing results what an acceptable level of intoxication is and at what point an employee's faculties are impaired. In fact, the test won't be able to tell you at what point or at what moment an employee's faculties are or were or are no longer impaired. And again, this is why direct observation of an employee is going to be key if you suspect that there's been consumption of substances in the workplace. Another important subject that should be addressed in a workplace drug and alcohol policy is the employer's obligations with regard to accommodation measures. So employers should know that employees who employees who take medical marijuana might suffer from a number of conditions that could be considered a disability under applicable provincial human rights legislation. And these can include suffering from seizures, anxiety, arthritis, cancer, chronic pain, or sleeping disorders. And medical marijuana as a form of treatment is meant to be the last form of treatment that a medical practitioner would explore in order to treat the condition that the employee happens to be suffering from, but it is becoming more widespread. And employers should know that drug and alcohol consumption could constitute handicaps or disabilities within the meaning of applicable human rights legislation. This does not include the recreational use of marijuana. So what we propose is that the employer establish a clear policy of non-discrimination, prevention, and accommodation with respect to employees who are considered to have a disability or handicap. And that would include employees who have a substance addiction. In cases where this arises, that an employee has a recognized substance addiction or has a prescription for medical marijuana, the employer is going to have a duty to accommodate up to the point of undue hardship. And undue hardship tends to be an extremely high threshold, which is going to require that an employer take a good look at the duties and at the positions that exist within the workplace to see if a disabled employee can be accommodated in a manner that allows them to continue to perform work. If an employer wishes to argue undue hardship, again, this is very onerous and the burden is going to be on the employer to demonstrate, but we tend to talk about things that could really threaten the viability, even the financial viability of the organization. The employer's duty to accommodate is going to stop at the recreational consumption of marijuana, this certainly does not equal addiction and would not be considered a form of disability or handicap under human rights legislation. And what we mean by handicap or disability is really an instance where an employee presents with a condition that is not transitory and really has the effect of impairing their ability to perform work or carry out their duties or their normal functions of life. Now, employers and employees should know that having a drug or alcohol addiction is not simply a get out of jail free card, but is actually going to lead to a number of obligations on the employer's part as well as on the employee's part. And these are all going to fall under the context of the accommodation process. So while the employer is going to have a duty to accommodate the employee within the workplace, it's going to be up to the employee to first disclose that they have a disability or an addiction and make a request for accommodation, because the employer can't be expected to guess or to foresee that an employee is going to be in need of such accommodation. Now, when an employee brings to your attention the fact that they have a recognized disability in the form of an addiction, and they request accommodation, an employer is going to want to collect all relevant information. And this could involve medical evidence of the dependency or any other supporting documentation in that regard, such as documents relating to compliance with a treatment plan that an employee might be following, or a medical opinion on the employee's fitness to work. So the employer should ask for relevant documentation, and the employee would then have an obligation to a certain extent, of course, to provide it in order to assist with the accommodation process. And if the employee doesn't actually have any documentation that will demonstrate or evidence their disability, then the employer and employee should agree for the employee to undergo an expertise in order to obtain the necessary information, diagnosis, and to get a recommendation on what form of accommodations would be in order. From there, the employer and the employee will jointly participate in preparing and executing an accommodation plan. And the plan is going to be something that permits the employee to continue to actively participate in work activities to the extent possible, again, up to the point of creating undue hardship for the employer. So as an example, the employee could perhaps be removed temporarily from safety-sensitive duties to the extent necessary and placed on administrative duties. And another aspect of the accommodation plan, it could also actually involve an employee's commitment to seeking out and attending treatment with regard to their addiction. Now, just to wrap up on one of the last topics that I'll discuss with regard to the sample policy, what employee responsibilities should be included under this policy, and what are some supervisor responsibilities that could be included as well. So employees should be expected under the policy, first of all, to comply to the fullest extent with the policy, and to report for duty unimpaired, and to remain fit for work throughout their shift. The employee should also be expected to take prescription medication as prescribed. They should also be expected to consult with their physician or pharmacist or other healthcare practitioner regarding the proper use of any prescription medication that the employee is taking, in order for the employee to be able to determine whether their prescription medication could potentially have an adverse effect on their ability to perform their duties in a safe manner. And if it is determined by the treating physician or the pharmacist or other healthcare practitioner that a potential impact on the employee's faculties within the workplace could arise, then the employee is going to have an obligation to divulge that either to their immediate supervisor or to HR or management in accordance with the protocol that's stipulated in the policy, to make sure that this is brought to the employer's attention and that any necessary measures are then taken, particularly for employees that are in safety sensitive positions. Employees should also be expected under the policy to seek advice or help if they have an addiction problem or if they are developing a substance abuse problem. They should also have the responsibility of reporting any concerns regarding potential policy violations to the employer. The employee should also have the responsibility of collaborating with the employer in any interventions in the workplace that are made or any investigations in the workplace with regard to potential drug or alcohol consumption that the employer happens to be investigating. And as I mentioned earlier, the employee should have a clear responsibility of maintaining the confidentiality of the investigation. And finally, the employee should be responsible for reporting to their supervisor or HR management any circumstances or any events that they bear witness to in which they think that might create a hazard to health or safety or some other form of risk, whether to employees or to the environment. As for the supervisor's responsibilities, they should be notified, or as soon as they're notified of a policy violation, or if they suspect that a policy violation has occurred, they should immediately either investigate or report it to someone who will investigate. And they should immediately remove the employee in question from the workplace. Okay, and we'll go straight to the question period now. We've had a few questions that have come through.
Yes, we do have some questions, but before we go on, I just want to remind everyone who's joined, some people may have joined late, to please go to the handout section on the go-to panel. You will find 3 documents for you, one of them being the presentation for today, as well as a template. So please, again, go ahead and open those documents and save them to your computers. And now I'll turn it back to Rhonda so she can address some of the questions. Thank you.
Thanks, Sylvie. So the first question that we have coming through, are recreational edibles going to be legal on October 17th? No, under the federal legislation that is coming into force on October 17th, edibles are not permitted. So they'll continue to be permitted only to those who have a prescription. Is there any legislation across Canada that is drastically different? Actually, one point that I should mention or reiterate, it was mentioned earlier in the presentation, the number of plants that an employee or any other person will be permitted to possess within their residence does differ from province to province. Under the federal legislation, they've capped it at 4 plants. And so up to 4 plants is permissible, but this the provinces have each come and had their word to say with regard to that. So some of the provinces have actually outlawed the possession of marijuana plants. And another point to mention is that the provincial legislations that are coming into force do have some differences with regard to the areas that have been carved out as restricted areas in which cannabis cannot be consumed. So you'll want to check with your provincial legislation to see exactly where it can and cannot be consumed. Another question that we have is, how do we address subcontractors or self-employed individuals working with the business? How do we extend the policies to them? And is it contractual? Yes, so I would certainly recommend that subcontractors or self-employed individuals or consultants that are working in conjunction with the company be subject to the policy. So the workplace drug and alcohol policy should specifically provide for that in the section in which it lists who is covered by the policy. So that should certainly include contractors, consultants, and others working with the company or providing services to the company. So the employer is going to want to bring this policy certainly to their attention anytime that they're signing a contract with service providers or engaging consultants or service providers. And you could even ask them to sign an acknowledgement of receipt and of compliance. And another step that an employer could take is to actually put a clause in the contract with the service provider stipulating that the service provider or any employees working for the service provider will ensure to be familiar with any company policies in effect and to abide by them. The next question we have is, when removing an employee during an investigation, should it be paid or unpaid? Now, when we talk about an investigation, suspension for purposes of investigation, we are not talking about a suspension for disciplinary purposes. That's entirely different. So a suspension for disciplinary purposes, and in those cases, an employer would be justified in not providing the employee's salary for the duration of the suspension. But when we talk about suspension for the purposes of investigation, we're talking more about something that could be considered an administrative suspension. That is not a punishment. And those should generally be paid. There are certain circumstances in which an employer could be justified in not paying for during the time of the suspension, but other than in those specific exceptional circumstances, if the employer refuses to pay the employee during the suspension pending investigation, then it could amount to a constructive dismissal. So the suspension for investigation should generally be paid. Now, again, at the end of the investigation, the employer could conclude that there's been a policy violation, and that could in and of itself justify a suspension. But at that point, we'd be talking about a new suspension for disciplinary purposes, at which case the suspension could be unpaid. Another question that we have is, can I ban possession in the workplace? And what do I do if I find that an employee has cannabis on them but has not consumed it? Yes, so the employer certainly has the prerogative to fully ban possession of alcohol or drugs in the workplace. And if they find, for example, an employee with marijuana on them, that would present a clear policy violation and should be considered in the same way as if, for example, they found the employee with a bottle of vodka on them. The violation would be treated like any other. Certainly, it's not perhaps going to be the most egregious of possible violations of the policy, but it should clearly be prohibited under the workplace policy, and it could lead to disciplinary measures up to and including termination where appropriate. Another question that we have is, how does an employee prove cannabis addiction? So one form of medical evidence is going to be a medical note showing what the diagnosis is, as well as any treatment documentation that could show that the employee did in the past or is currently undergoing treatment for their addiction. Perhaps any hospital records showing a hospitalization for that particular reason. These are all types of evidence that the employer could ask the employee to provide to demonstrate their diagnosis and justify their request for accommodation. And I think we'll have time for one more question. We have staff in hotels staying overnight. can we limit consumption even when the employee is not on the clock? So certainly the workplace policy could cover not only instances in which the employee is actually working on the premises, but even when they are outside of the premises, so long as they are performing work-related duties or representing the company. So scenarios in which an employee is staying overnight could certainly be covered by the policy, and in that case, we would consider that the employer is paying for the accommodations and that the employee is there in relation to work-related duties. So that could certainly be covered by the policy. And that's all the questions we have for today. Thank you very much for your participation.
Thank you, Rhonda. So this is Sylvie again, everybody. I'm just going to stay on for a minute or two for those who maybe are still trying to print up the handouts, or if you're looking for them. Again, it's in the panel under the section called Handouts. You will see 3 documents. You simply have to click on each one and then save them to your computer. So we will just, Rhonda and I will hang around for another minute or so. Don't forget to look out for the email you'll be receiving with the recording to the session. And if you have not been able to get the documents, please send an email to webinars@cfib.ca. And that's all we have for today. We will now end the webinar.